Talk shoes. Recorded live.
Hello, ladies and gentlemen. This is Rod. With recent discoveries of what we have found about the bankruptcy of 1933, the Social Security Act of 1935, Alien Registration Act of 1940, and the Federal Reserve Act of 1913. And the Federal Register, 1935, National Industrial Recovery Act, 1933, Executive Order 6174 by Franklin Delano Roosevelt. All this goes back in from 1913 from the Federal Reserve Act, was the intent to strip the American people of any lawful money by replacing it with Federal Reserve notes, which was from a private credit corporation from outside of the United States that Congress made a deal with. When the stock market crashed in 1929, this allowed them to point the finger that the United States government was not capable of handling its finances and that it was untrustworthy, and it needed someone to come in and control the financial world for them, which was a deal to steal everything off this country, including you, because you're listed as property, and all your property that you have and all lands in this country. 1933 come up, they did the Public Law 148 Stat C1, where they turn around and they stripped the gold out of the people under penalty. They also passed that 49 Stat 3097 Treaty Series 881 Conventions and Duties and Rights of the State, putting this country under international law. They went in after they stripped the people of the money and placed us under international regulations. Because of the recession, depression at that time period, they passed the New Deal for administrative. They passed the National Industrial Recovery Act, which was to create jobs, but it wasn't to create jobs for the American people as what it was for the administration side. The Executive Order 6174 basically set up the administrative side of this thing for public works, for everything to come under administrative. The Federal Register allowed administrative committees and the president to come in and codify the statutes and place them under administrative rules, regulations, under administrative guidelines. As we are not part of that administration, they did not apply because it was purely administrative. Throughout the history and through the research that a lot of you have done, there's been so many pieces put in, but nobody has really been able to put all the pieces together on all of this. The history goes back in that we know that they're dealing with the trust. All crimes are based on basic commercial crimes. Not saying that there are not legitimate murder, hit and run. You know, there are, but they're not being charged properly. Most crimes fall under commercial. Even though they set the Social Security up in 1935 to give the federal grant money to the states, every time the state reported a new birth, produced a certificate for that birth, the federal government granted federal grants to that state for that birth certificate on name of that person. So what we're dealing with here, every charge that is being done in the court, it is the birth name that is being charged. Even though they are pulling the natural person in, the flesh and blood in, the charge goes back to that birth name, not to that natural person. This is where the concept and where the issue is coming in. Is they're dragging us in, but they're not telling us it's the birth name that's being charged, because that birth name being registered to the state and the state receiving federal grant money on behalf of, they have to find ways to use this money instead of using it on behalf of the people. So the state is embezzling it, and the court system is embezzling it. And this is where the lawyers, the Bar Association, the judges, the courts, these people have, if we sit back and look, they have ran the biggest fraud on the American people in this country. Because you're getting nailed for a tail light being out or a license plate light out. There's no injury there, but they're charging you criminally for this. There's no corpus delicti. There's no injured party. The attorneys, lawyers, judges are wanting to play total ignorance. They just don't comprehend. They just don't understand. We just don't know what you're talking about. But yet, proven history has sit here and showed they're selling our signatures. And this is what McFadden got into in 1932 on the floor of Congress. It isn't the liquor. It isn't the material. It is the signature. It is that name that's being sold. It is that name that is being monetized. We have proven that in foreclosures, because the people coming in and going back and doing the research through Security Exchange, through Bloomberg, the fact that names used to come up on Dun and Bradstreet, used to come up on Fidelity whenever we used to have courts, and because we started exposing this, they have now started to take these offline so we cannot find them. Really what this comes down to is this. You've got a judge that sits on the bench that plays administrator. And a lot of people, what they're saying, this is probate court. And that technically, with what we're finding out, it's going right along. This is probate court. But they're not acknowledging any of this. It is total deniability on their side. But the fact that it is getting exposed, the truth of it is coming out. With what recent discoveries that we have made here, under Rule 19, under the Federal Rules of Civil Procedures, of other parties being brought in, indispensable parties being brought in. They're not being named. Whenever the police officer pulls you, tags you, IRS pulls you, tags you, whenever banker tags you, that indispensable party is not being represented in that courtroom in the open. And I'm using it by in the open. They're not acknowledging it. They are not sitting here telling the client any of this. It is a secret that they have kept among themselves. They fail to disclose the whole proceedings of a courtroom. The prosecutor walks in, which is the attorney, representing the state, representing the government. He is really the trustee in this. The judge is the administrator. In order to relieve the burden off of the prosecutor or the attorney, the court has to appoint a lawyer, somebody, a friend. And this goes back into the history of what we've talked about here, ladies and gentlemen. There's no legislative law for lawyers. They've always been a friend. They've always been someone that was separate from the system, but yet part of the system. The attorney was actually part of the system. The judge is actually part of the system. So they brought in a third party, known as a lawyer, into these courtrooms. Throughout the years, they became bar members, and therefore, because they became bar members, they have now started to conceal a lot of the fraud, because stop and think, it is the lawyers and the attorneys. These are the ones that's creating the law. These are the ones that are creating the contracts. These are the ones who's writing all this stuff up. So they're setting things up knowing full well that they can walk in with pure immunity for not doing a job and being able to Shanghai and shake down the trust and swindle and embezzle out of that trust because of the way they worded these things. With what we have discovered here in the last few weeks and what we have talked about, it's about justice being blind. You have your unknown police officer out here being told to meet a quota. Go out here, do whatever you want to do, we'll cover you, we'll protect you, we will lie, we will protect you in any way we need. Even if you murder them, we'll call it self-defense because you was in fear of your life. They're not telling the police officer the whole thing of this trust, where they are going in and tapping the trust and putting stuff on the stock market, and they are securitizing and filling their pockets. The judge is coming into this courtroom playing blind, deaf, and dumb. I'm using the word playing. They're not blind, they're not deaf, and they're not dumb. They know exactly what they're doing. They control that room. They control what comes into evidence, what does not. Every court case is pre-planned before the client walks in. All parties knows how it's going to go. Before it starts and before it ends, they already know what the game is. We have heard that these courts are nothing more than theaters. These are all actors putting on a good show. When the prosecutor is walking in, like I said, he is the trustee until they appoint a lawyer. That lawyer now is an officer of the court. He's an officer of the state. He now, the burden of the trustee from the attorney has now shifted over to the lawyer in that courtroom. And this is something they're not telling you. Through evidence of other cases, we have heard different things that has come back in that ties all this up. The moment you sit down and tell a lawyer that he's a trustee, they automatically want to quit. The moment you bring up a birth certificate into the courtroom, the judge automatically dismisses. So there are things that has popped up that has fueled this line of thought. Is the fact that that lawyer is acting as that indispensable party representing the state, which is the governor and the attorney general, the Social Security Administration, and the United States. He is actually representing that trust. He is the trustee of this. This is where the scam comes in. Is that lawyer does not put a defense up for the client. If he was to sit down and say, Your Honor, the prosecution here has the burden of proof, and he has to sit here and produce the corpus delicti, this would throw a monkey wrench. We will find that the attorneys and lawyers do not play this with each other. It's really coming down to where there is no laws or anything. It is just, he did, and your attorney admits, and you're crucified. These courts are a joke. There is no adversarial system in these courts. These courts are nothing more than hanging courts. When you're forced to hire that lawyer is coming in, is representing the state, the Social Security Administration, and the U.S. government on that trust of your birth name. Because we have found in vital statistics under live birth that when it defines a person, it defines that person as a trust and as an estate and as property. It's corporations, it's partnerships. We are being tagged as partners in this when we're in that courtroom. Problem of it is, if we're partners, we're not being paid. Even a silent partner gets dividends off of his investments. You and I are not getting any dividends. That lawyer is intentionally and knowingly misrepresenting you in that courtroom because he is not bringing up any of the issues. He's not bringing up any laws. And the moment you talk to him about the laws, well, that's nonsensical. That's unintelligible. That's frivolous. I don't know where you're getting any of this. But yet when you sit here and you lay the books out, and you sit here and show him Supreme Court rulings on decisions, and you sit here and show him American jurisprudence of decisions, and you bring out the statutes and you show decisions and legislative and terminologies and definitions, they don't want to go there. Well, that isn't how we operate. These aren't what we're running under. Well, what are you running under? That's what I was charged under. This is the definition for this charge. How does it apply to me? They don't want to go here. So the whole fraud comes down to this, ladies and gentlemen. Is that judge is the administrator in this. He's blind. The attorney represents the federal government, bringing a claim against the trust. He's the trustee. They have to give you a lawyer. That lawyer now takes the responsibility of that trustee. He now represents the state, Social Security Administration, and the U.S. government. Now, the prosecutor, the attorney, does not have to name the indispensable parties in that courtroom. Why? Because now that attorney assumes all three positions, but you're not being told this. They're not disclosing this issue. Whenever you come in and represent yourself because you're under that all caps, that judge is looking at you as that trust and as an estate, and therefore you are mute. Technically, yes, you are dead. He cannot hear you. So therefore, anything you say now comes into probate because your side has failed to show up. Your side has failed for proper representation. Now the state automatically gets it because we didn't know enough to go back and push the issue to bring ourselves in on an inner of appearance and make the separation between that all capital name being a ward or an estate or a trust or property. We did not know to make the distinction between us and that all capital name. So therefore, because we did not, we forfeited. And we got hammered anyhow. This is the scam that they're running on us, ladies and gentlemen. This is the scam. Eventually, this is going to come out. Eventually, what we're seeing here tonight, it's like the mortgage foreclosures. 4 or 5 years ago, we was bringing this stuff up, and so was other people. And now we're seeing the securitization. What was said 4 or 5 years ago is now coming out to be the truth. That's the same thing with this. The time's going to come with what we're broadcasting here, that the judge is playing administrator. The attorney is the trustee for the state. The administrator has to appoint opposing counsel to represent the state, the Social Security Agency, and the United States. He has to appoint the indispensable parties in order to steal out of the trust, in order to embezzle. And then the attorney steps off to the side and pats you on the back, or motions to the judge, points over to you. We, not knowing, accepted, and we now took that responsibility as that secret partner in this case, which now we became liable. This is the fraud. This is how simple it is. A lot of you people have been out here. You've come so close, but there's pieces that you were missing. I am putting this out to you for you to think about. With what you've already discovered, with what we've discovered, is that the court system is nothing more than a sham. It's nothing more than a kangaroo setup. The judge is nothing more than plain administrator. The prosecutor is nothing more than the trustee, and then the administrator has to appoint another trustee to cover the government, to make it look legitimate, make it look like there is some type of integrity in this courtroom, when there's no integrity at all. Because when that lawyer gets appointed, like I said, they're not telling us that he is taking over that indispensable party. They're not telling us that the state should have been named as a defendant. The Social Security Department should have been named as a defendant. And the United States government, under the United States or United States of America, should have been named as a defendant, as indispensable parties. They are always leaving these three out in every single court case. This is why they appoint that attorney, or that lawyer, excuse me. That's why they appoint that lawyer. That lawyer takes all three positions, unbeknown to us until now. Time will come. This will be exposed. But we're putting it out now for people to think about. Because like it got put out about the foreclosures, about the embezzling, about the securitization and the selling of your signature. This is what exposed the banking fraud. We start getting this message out now that judge is acting as an administrator, playing blind, deaf and dumb here, and the attorney representing the United States, representing the trust, wants to embezzle out of the trust. But in order to do this, they have to appoint a lawyer to make it look legitimate. And then bring him in as the indispensable three parties here of the state, the Social Security agent, and the U.S. government. He doesn't put up a defense. He pleads guilty and then shifts the burden over to you as the silent partner for you to take the fall so they can sit here and strip your trust account under that birth name because it's got money in it so they can put it in their own private account. This is how simple this thing has come down to. This is how simple it has come down. And it's taken us a long time. But because of the different people who have come out and did different things, because of results of what they've done, has allowed these pieces to fall together with what we're explaining now in these courts of what they've done to us, what they're doing to us, and how they're doing it. We need to start coming in as that third party intervener into this thing, or that third party of interest. We need to make the distinction between that name that's on that docket or on that court filing as being a ward or an estate or a trust. And we need to start asking, is it not the birth name that's being charged in this courtroom? Is it not the birth name that's being charged? that if you can have your birth certificate with you, bring in your birth certificate. It says, here is the birth name. This is what's being charged. Is it not true that you're charging the trust? Is it also not true that you should be naming the indispensable parties, such as the state, which would be the Attorney General and the Governor? Should not be naming the Social Security Administration, as they are the ones who give the federal grant to the state, to the Attorney General, and to the Governor, that they are the receivers and trustees of this birth name? And should not the United States of America be also brought in here as an indispensable party? Is this why you want me to have a lawyer? Because he's now taken their position? Ladies and gentlemen, we need to start hitting these courts up on this, point blank. Because all these crimes are commercial. And from what we've learned here off this federal jurisdiction video, everything falls under banking, falls under trust law. Everything falls under corporations, falls under partnership. This is why they define a person as a partnership. Because under that birth certificate, under the bankruptcy of 1933, the state is the administrator and the trustee. We were supposed to be the beneficiaries of this, but they made themselves the administrator. They made themselves the trustee. They have made themselves the beneficiary of this, because you and I are not getting anything. Our bills are not being paid. Our schools are not being paid. We're still being charged taxes for the property. We're being charged taxes for the vehicles. We have to pay for everything with phony money. Ladies and gentlemen, this is the biggest scam that has ever been ran. And we need to start challenging this in the court. Is it not true that you're charging the birth name? Is it not true that that birth name is a trust? That birth name is not listed as a flesh and blood. Isn't it true that it's listed as a trust and an estate and as a partnership? And this is what you are charging. Then why did the prosecutor not sit here and bring in the indispensable parties, which would be the state where that birth name is registered, the Social Security Administration, and the United States government? Is this why you want me to have a lawyer? Is because he takes all three of these and he's going to plead guilty? We need to start bringing this kind of stuff up in a courtroom, ladies and gentlemen. We need to hit them point blank with this. This is something that needs to be done. Because now they don't have an answer, because they cannot prove, because they do not have a corpus delicti. If you did not murder anybody and you did not damage anybody's property, but you are being drugged in here for seatbelt violation, you're being drugged in here for doing 35 and 25, and there was no damage, there was no threat, no harm. You're being drugged in here because you had a tail light out or a headlight out, you didn't use a turn signal, nobody was harmed. These are all commercial crimes. You didn't pay your taxes. That's all commercial crime. It's that birth name that they're charging, because that birth name is a trust. That birth name has grant money tied to it. Think about what we're talking about here tonight. Think about what we're sitting here saying. We need to start cornering these courts and start bringing this issue up. And start demanding who is the corpus delicti, because that corpus delicti goes two ways. One, they have to produce who was harmed, who was injured, and who is being named, and what is the dollar amount value attached to this, because this is what this guy was getting into in part one of that federal jurisdiction under the 12b-6. Because you fail to state a monetary value, because you and I are not in the beneficiary position of this trust. Therefore, that trust name is the monetary side. The living man, the living woman is not the monetary side because we're not receiving any benefits from it. Think carefully about what we're talking about here. Think back and think carefully about what we're talking about. You and I are not receiving any benefits. You and I are not receiving anything out of that trust, but the state is. They are the administrators, they're the trustees, and they are the absolute beneficiaries of it. And when we walk, they want to make us a partner. And that's exactly what that lawyer does. He turns around and it sits down. Here's the partner. I'm no partner. I haven't got anything out of it. I have not got a dime. The lawyer is the trustee in this. He's the one that's receiving. You want to see how fast he shoves this back over to the prosecutor? This is just a little simple thing here tonight we're talking about. There's not a whole lot of detail. But just putting out for a line of thought for you to sit here and think about how they're running the courts. And the biggest scam that's ever been perpetrated on the American people in this country. And it's taken us a lot of years to figure it out. It's taken us a lot of years to figure it out. But now we've got it right down to where, because we know for a fact the birth name is a trust. We know for a fact that that birth name does receive money on federal grant. The state receives it. It is an absolute proven fact. It's in the laws. Their laws. They wrote them. It is an absolute fact that that birth name is a trust. Because it is written in their laws. So this judge is doing nothing more than sitting there as a mediator, nothing more than an administrator, allowing the state to represent the trustee. And when we get brought in and we don't distinguish the difference between that trust name and our intervener self in this thing, or party of interest, the court looks at this as if we never showed up. So they walk right over us. That's why they don't accept anything, because we did not enter our appearance in. That's why they want to give us an attorney. That attorney sits here and represents the state, Social Security, and the United States government. But they don't tell us this. I said I'm going to keep this short. About a half hour. That's all we need. Like I said, think about what's being said here tonight. Thank you. Good night.